Команда юридического института РУДН в 2014 году в 4-й раз приняла участие в международных соревнованиях по торговому арбитражу в Вене, Австрия. Целью модельного судопроизводства является глубокое изучение международного коммерческого права и арбитража для разрешения споров посредством применения права к конкретным потребностям клиента и подготовка лидеров завтрашнего дня методом альтернативного разрешения споров.
Takes account of how hospitals concerned that as a public hospital it is accountable to Equatoriania's taxpayers.
Yes, thank you. Good morning, distinguished members of the Arbitral Tribunal. My name is Anastasia Efimova, and I'm going to represent claimant in this case. This is the case where respondent is trying to avoid arbitration at all costs and raises the following issues. First of all, respondent states that arbitral tribunal has no jurisdiction to hear this case. Secondly, respondent states that framework and sales agreement does not cover claims arising out of sales and licensing agreement. And third, respondent states that in any case both disputes should be heard separately. I'm going to address this issue in the respective order. And my first submission is that the arbitral tribunal has jurisdiction over this case because the arbitration clause contained in Article 23.3 of the Framework and Sales Agreement is valid, and its validity is conditioned by several grounds. First of all, it is valid because it is contained in a contract which was negotiated and properly signed by the parties. An inclusion of the appeal and review mechanism does not invalidate the arbitration clause.
В этих самых крупных в мире соревнованиях приняли участие около 300 команд из более чем 70 стран мира. Россию представляют 5-6 команд ведущих вузов страны, и среди них команда РУДН.
As we have mentioned, I will need 14 minutes, reserving 1 minute for the rebuttal to make my submission. The case at hand is all about the inconsistent behavior of the respondent, and as it turned out, its attempts to escape the liability for the breach of contract. So, in 2011, the parties signed the sales and licensing agreement, and the claimant, having fulfilled his obligations under the contract, never got the full payments from the respondent, who now states that the contractual terms are not binding. And, however, the claimant, having revised the standard terms of 2011, informed the respondent of the overall of the standard terms, and the respondent never informed the claimant of any problems, of any issues concerning the understanding or comprehending the text of the standard terms.
Moreover, the sales and licensing agreement is not a contract for the sale of goods within the meaning of the CILG. Now, claimant wants the CILG to be applied to the sales and licensing agreement in order to obtain $1.5 million that do not belong to it. I have 3 submissions to make following the counsel for the opposing parties' submissions. The first one is that the CILG is not applicable to the sales and licensing agreement pursuant the choice of law clause. The second one is that Section 22 of the 2011 version of the standard terms does not lead to the application of the CILG. Finally, the final issue here is if the sales and licensing agreement is a contract within the meaning of the CILG, and to the materials. Furthermore, the software and the materials are not inseparable in terms of fact.
On the jurisdiction and on the issue of the applicable law and on the procedure part, I thank both parties.
Thank you.
Thank you.
Thank you.
Good afternoon, ladies and gentlemen. Are we ready to start? Camera rolling.
Игры судили около 900 практикующих юристов.
My name is Peter McQueen. I'm from my accent, you can hear that I'm Australian.
Подготовка к соревнованиям шла 6 месяцев, с октября по март. Написано около 100 страниц позиций истца и ответчика, прочитаны сотни статей.
My client is a non-sophisticated party and who just wanted two things, functioning contract and functioning technology. However, it has got nothing. Therefore, on behalf of respondent, I have three main submissions to make. First of all, the arbitral tribunal has no jurisdiction over this case. Second, framework and sales agreement does not extend to cover claims arising out of the sales and licensing agreement. And third, in any case, most disputes cannot be heard within a single set of proceedings. So, my first submission is that the arbitral tribunal has no jurisdiction over this case, because the arbitration clause contained in Article 23 of the Framework and Sales Agreement is invalid, due to the fact that it is the party's initial intention was infringed when the claimant drafted arbitration clause with completely inappropriate appeal and review mechanism.
Of course, with business relationship with respondent, claimant, in the sense of good cooperation, accommodated all the needs of respondent. Moreover,
Команда под руководством тренеров доцента Ситкаревой Елены Витальевны, кафедра гражданского права, и старшего преподавателя Челенгаряна Камо Павловича, кафедра иностранных языков, готовилась после уроков, а также по субботам. Тренинги продолжались по 5-6 часов.
Thus, this tribunal has jurisdiction for there is a valid arbitration agreement contained in the Article 23 of the Framework and Sales Agreement. Second, the very same arbitration agreement also governs the claims arising out of the sales and licensing agreement. And finally, both claims should be heard in one single set of proceedings before this tribunal. Moving to the first point of my submission.
Каждая тренировка тщательно фиксировалась видеокамерой для дальнейшего просмотра и разбора ошибок.
Main intention of the respondent to include the appeal and review mechanism into the dispute resolution clause was not to comply with the provisions of circular number 265. It is stated in procedural order number 2, record page 58, paragraph 10, that respondent wanted to avoid public discussions regarding the substance of this case.
Contract negotiations, as it provided a dispute resolution.
Участию в конкурсе предшествовал национальный тур, проходивший в МГУ, а также тренировочная игра с командой Высшей школы экономики в фирме Бейкер и Маккензи, любезно организованной капитаном команды Станиславом Трофимчуком.
Claimant requests the tribunal today to hold that the CISG applies to all claims arising under the sales and licensing agreement. To arrive to this conclusion, the claimant provides to the tribunal three following submissions, and that is first, the July 2011 version of claimant standard terms has been validly incorporated into the sales and licensing agreement.
Good afternoon, honorable members of the tribunal. My name is Dania Babic and I represent the respondent on this case, speaking on the merits. My submission will take 14 minutes, reserving 1 minute for the rebuttal. Following the structure that was named by the claimant, the respondent submits that the CISG is not applied to the contract since, first, the July 2011 version of standard terms and conditions was not validly included and incorporated into the contract, and it simply didn't become part of the contract. Second is that Section 22 of Standard Terms and Conditions of Sale of 2011 should not be applied, since the only version that was included into the contract is the Standard Terms of 2000, and the choice of law clause of Standard Terms of 2000 should be applied to the contract. The third issue is that the sales and licensing agreement is out of the scope of the CISG, since the nature of of the contract contradicts to the Article 3 of the CISG.
Thank you. Honorable Tribunal, I would like to rebut on one point concerning the exclusion of the CISG application under Article 3.2, as was mentioned by the opposing counsel.
The parties agree upon how to proceed.
Yes, Madam Arbitrator, we agreed that respondent shall start with procedural issues, followed by claimant, and then claimant shall start with the merits, followed by the respondent. Each party reserves 14 minutes for the main presentation and 1 minute for the rebuttal.
As my co-counsel, Mr. Tao Patel. Together we are representing respondent in this matter, Health Hospital. I'll be speaking in regard of the procedural issues concerning, first, whether the tribunal has the jurisdiction to deal with the claims from the contract, and second, whether the claims should be heard in a single arbitration. After that, my co-counsel will be speaking in regard of the merits issue concerning the law applicable to the licensing agreement. I would like to proceed with my first submission, which is the tribunal has no jurisdiction to rule on any claim arising out of both contracts. My argument is separated into two parts. The first one concerning the framework and sales agreement, and the second one concerning the sales.
Don't they provide different, seats?
For the second?
Yeah.
For the sales and licensing agreement. For the sales and licensing agreement, the dispute resolution clause contained in the 2011 standard is not incorporated either, because the terms in both dispute resolution clauses in the sales and licensing agreement and the standard agreement have different provisions.
My submission will take 14 minutes, and 1 minute I will leave for the rebuttal. In this case, the respondent is trying to avoid arbitration at all costs and raises three main issues. First, respondent states that the arbitral tribunal has no jurisdiction over this case. Second, respondent states that framework and sales agreement does not extend to cover claims arising out of the sales and licensing agreement. And third, respondent argues that both disputes cannot be heard within a single set of proceedings.
23.2. That both parties shall have the right to bring any and all claims?
Yes, Mr. Arbitrator, you refer me to the sales and licensing agreement,
Yeah,
am I correct?
23.2, it's I think page 19.
Yes, the parties have the right, but they are not obliged to bring any and all claims.
Команда РУДН прочно обосновалась в середине турнирной таблицы и, несмотря на свой небольшой опыт, делает все возможное для достижения новых успехов.
It was respondent's intention to include such a review mechanism to the arbitration agreement. However, we must admit that it is invalid due to the exceeded the extension of the ground.
So the claimant states that CISG is applicable to the contract due to several reasons. First is that the July version of standard terms and conditions was validly included into the contract and it became part of the contract and its contractual terms are binding. Second is that Section 2 of the Standard Terms and Conditions of 2011 provides for the application of the CISG to the contract. And third issue is that the sales and licensing agreement is within the scope of the CISG because it is a contract for the sale of goods. Of the CISG is valid, and consequently the third issue is that the sales and licensing agreement is a contract for the sale of goods in the sense of the CISG, and it is within the scope of the CISG.
Команда РУДН благодарит руководство института, руководителей кафедр и, конечно же, руководство университета за оказанную материальную и психологическую помощь во время подготовки к играм.